Testing. Hey, what am I doing? Hey. All right, welcome back. Miss me? No, you don't lie. You don't need to lie. I miss you. I do. I was like, why not in class anyway? But it was good. Yeah, I don't usually cancel class, but it was important for me to be where I was. So thank you for letting me do that. We have an event today at 1 o'clock. Addie, you want to just mention it, please?
Yes. Come to the FedSoc event today, right after class at 1. On this floor, you're going to have to walk far. There's Chick-fil-A in room 5.
Say no more.
Campaign finance law is stupid is the title, and we have 2 attorneys. You know one, right?
I know both of them.
Okay, he knows both. Steve Klein.
I've known Steve since he was in law school.
Is it Jared?
Jared. But I've known Steve since she was in law school. We go way back.
Yeah, it's both of them speaking. There will be Chick-fil-A, and do they have the same view on campaign finance, or are they going to debate?
We'll see.
Okay. Very interesting. Campaign finance is, I mean, like,
you'll learn this in First Amendment next semester. You're all taking First Amendment next year? So eventually. Okay. No, you have to take it eventually, but okay, very good. All right. Welcome back. Let's get back in swing of things. Let's recap a bit. We've been talking about the Reconstruction amendments. And there's these 2 kind of themes, right? First, what do the amendments actually say, and what did those who draft them intend to do? And second, what did the courts do with these amendments when they got them? On the first issue, there's some very good evidence these are meant to be very broad provisions to protect civil rights. Yet, when the courts got to them, in a series of cases, they read them narrow and even more narrow. Well, let's just review the cases, right? What was the very first case about the 14th Amendment? It was slaughterhouse. The butchers said, aha, privileges or immunities. That gives me a right to an occupation, right to ply my trade, the right to be a butcher. The Supreme Court said, no, it doesn't. The phrase privileges or immunities means only a very narrow set of federal rights. Access to the treasuries, protection in the high seas, access to the navigable waters. The next case, Myra Bradwell, the woman who wants to be an attorney, right? She said, aha, I have the right to pursue my profession. And the court says, no, you do not. And then you have Justice Bradley's notorious concurrence speaking about the plight of women as reproductive organs, more or less, right? Okay. Then we have Cruikshank. What was Cruikshank about? This is about the Colfax massacre, this tragic slaughter of the freedmen. And indictments were brought saying that this lynch mob deprived people of the right to freely assemble, their right to bear arms in defense of themselves and their families. What did the Supreme Court say? No go. That whatever privileges or immunities means, it does not include the Bill of Rights, the first 8 amendments. So again, arguably, the framers who wrote the 14th Amendment intended for that text to refer to natural rights like contract and property. They intended privilege or immunities to refer to the Bill of Rights, There's very good evidence to that effect. But in those three cases, Slaughterhouse, Bradwell, and Crookshank, the court said no. All right. Then we move on, right? We have the next batch of cases involving the 14th Amendment. All right. What's the next case we studied? Strouder. Actually, skipping one. Civil rights cases. You're from the one. But you're right. Strouder is the one after. I'm taking my chronology right. We have the civil rights cases. This case involves the Civil Rights Act of 1875, a very important piece of legislation. This law made it a crime to segregate in places of public accommodation. Theaters, hotels, restaurants, trains. And the executive branch, the federal government, brought indictments against segregationists, saying you cannot exclude these Black customers. Again, it's like Crookshank, right? The federal government was bringing these prosecutions against people who were violating the amendment. And what did the courts say in the civil rights cases? 8-1 vote. The court said the 14th Amendment only prohibits state actors, the government, from engaging in segregation. The Constitution says nothing about private citizens ought to do. So the indictments were invalid. In dissent, who'd you have? You had Justice John Marshall Harlan, one of my icons. And Justice Harlan explained that these common carriers, that these public accommodations are basically state actors. And he went further. Where is it? One of the questions for the day. He described segregation as these badges or reminders of slavery. That slavery was not just referring to involuntary servitude, that slavery was greater. That slavery referred to the system of inequality, of inferiority. But Harlan was by himself. He was a lone dissenter in the civil rights cases. Same for Plessy, we'll come to later in this class. Then we have Strouder. Thank you for reminding me what the case was next. Strouder. And this case seems to not quite fit the trajectory. Same for Yick Wo. We'll get to Yick Wo today as well. Strouder and Yick Wo are kind of the outliers, where the court actually finds the state laws to be unconstitutional. So what happened in Strouder? Here you had a Black defendant who was being charged with murdering his wife. And by the way, he did it. This is not a case where he's being set up. The guy did it. He killed his wife in a gruesome fashion. It's awful. Okay. Say what you want. He did it. But the jury, the veneer, that is the people who could be pulled for jury service, were only white men. Black men could not serve on the jury pool. So he sought to remove his case from from state court to federal court. Why? He said because the all-white jury was denying him his rights, his civil rights. And this case raised some difficult questions. Is jury service a civil right? Is a political right? What kind of right is it? And the majority doesn't really get bogged down in that too much. The majority simply says that this state law, was a violation of equal protection. And they have Justice Field in dissent, and Justice Field says, wait a minute, there's no right to serve in a jury. Children can't serve in a jury. Women can't serve in juries. Why is this the case? He says further, are we to believe that a white jury cannot be fair and impartial? Is there any evidence of this? But that was it 7-2? I think it was a 7-2 decision in Strouder. So these cases leading up to today's reading kind of veer in different directions. It's pretty clear in the civil rights cases in Slaughterhouse that the Supreme Court does not want the 14th Amendment to be kind of a censor, right? A power to stop state legislation. But at least in the case of Strouder, they're saying, okay, this is too far, right? You can't exclude all Black people from a jury, right? That's a bridge too far. And Yick Wo, we'll get to later. You can't exclude all Chinese people from the profession of laundry, right? It goes a bit too far. But then we get to the Plessy decision, which was 8-1. And that was basically the end of the road, right? Whatever sort of hope, whatever optimism may have existed about the Supreme Court died with Plessy. Now, most people know Plessy. I'm sure you've all heard of the case, but people don't realize what came before it. Plessy was not the first stop on the train, no pun intended. It was the last stop on the train, right? You need to talk about Slaughterhouse killing PRI and Bradwell as well. You have to talk about Crookshank upholding the right of these people to massacre the freedmen. You have to talk about the civil rights cases, which eviscerated this landmark law when Congress tried to protect civil rights. Right? Plessy is just kind of the final destination. It's not the start of this journey. And again, this is a 25-year struggle, right? You read all these cases in about 2 or 3 classes, right? It's like, oh, whatever. No. This is from the 1870s to the 1890s. This is a quarter century. I mean, your entire adult, about 25 years old, right? Your entire life is how long this took to play out. And you didn't know at the beginning what was going to happen at the end. And you have an entirely new set of judges on the court who are ruling on these matters. By the time you get to the 1890s, all the Lincoln appointees are dead. They may have a couple Grant appointees left, but it's a very different court. And think back to the Chase Court, the legal tender cases, how the membership flipped so suddenly. They weren't just changing people's views on paper money. These are also views on civil rights and the 14th Amendment. So everything in this class sort of comes together in ways that maybe you don't see at first blush. Okay. How are we doing here? Good? All right. I want to start off by focusing, as we ought to always, on the text of the Constitution. And, I had a professor in law school. He said, you can't, your con law exam is closed book except for the Constitution. Yeah. Why is someone on Zoom? They're not allowed to be on Zoom. Yeah, that's not an option. I mean, I'll let him in, but you're not supposed to do that. I mean, it's not a. We actually had a vote on this. We had a vote on this a couple years ago. By the way, I can't get YouTube to work in this classroom for whatever reason. It keeps. No, I'll upload it later. Don't. Whenever I try and do a live stream, it does this weird glitch where it randomly stops recording the audio. And I can't resume the audio recording mid-turn unless I start and stop again. It takes too much work. So I'm just going to record it locally and upload it later. So I have it for YouTube later. But anyway, so we actually had a vote on this after COVID. Like when COVID happened, we said, okay, everyone's on Zoom. And then when COVID was over, it's like, okay, well, people are, infected. Sorry, the scare quotes, and they can make other people sick. We should let them stay at home indefinitely. You usually get like, 5 absences, but if you were infected, you may miss like 10 classes. So we said, okay, fine, you can stay in Zoom. Then we said, no more of this, no more excused absences, no more Zoom attendance. So Rick, you're here, but don't do this again. Okay. Where was I? So let's talk about the text of the 14th Amendment. And we have these 3 clauses. And the readings for today, I hope you read it. You should have read it. It's actually an excerpt from my colleague Randy Barnett's work on the meaning of these texts. So we have these 3 provisions. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens, nor shall any state deprive any person of life, liberty, or property without due process of law. And the last one, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. So what's significant about the privileges or immunities clause? It refers to a particular type of state action. No state shall make any law. Which branch of government is that provision directed at? The legislature, right? It's directed at legislature. The next one. Nor shall any state deprive any person of life, liberty, or property without due process of law. Which branch of government is that one directed to? You might say the courts, right? The judiciary. And that's partially right, but not entirely right. the executive, and maybe what else? The legislative. All three branches of government can deprive you of your life, liberty, or property. I'll come back to that in a minute. And the third one, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. Which branch of government, my friends, protects you? Executive. So these three clauses operate in very different ways. Modern doctrine jumbles them all together, but if you actually think about the text, they're very different. So let's just start with this phrase, due process of law. Okay. What does this phrase mean? The due process of law. I never learned this in law school. You'll get it. This is a very ancient phrase. By the way, the year today is 2025. What happened 810 years ago? Magna Carta. In fact, to be precise, the Magna Carta we studied was actually from the year 1225. So actually 800 years this year. Okay, so what is Magna Carta? Magna Carta, the Great Charter, Magna Carta. This was one of the first documents in world history where a king, a powerful sovereign, agreed to limit his own power. Now, this was not voluntary, to be very clear. This was not voluntary relinquishment. But he had a king named King John, who was not a very popular king. And he was accused of abusing his power, as many kings did. At the time, there were these barons, these kind of lords of the land. And they were basically threatening to overthrow the king. So King John, to avoid basically losing his throne, agreed to this charter, this grand charter, this Magna Carta. And he basically agreed to limit his power and those of his subordinates. This was signed in the year 1215 in Runnymede, England. If you ever go to Runnymede, England, there's actually a monument put on by the American Bar Association. 10 years ago, I actually took this is a disaster. They actually had a copy of Magna Carta in Houston at the Science Museum. I took a group of students to go. I'm still mad about this. I never did a field trip ever again. Half the students bailed on me. They never came. Never pay for their tickets. I actually have to eat the cost. They had like a legal, we had a legal writing memo due. I'm sorry we didn't go. I was so mad. I never ever again. But I arranged a tour for my students. They didn't show up. I was so mad. But about half the kids, like 80 section, maybe 40 were there. I was so anyway, but my point is that yeah. Yeah, it was a lot. Anyway, those students are long gone. You're all here. So anyway, my point is that a Magna Carta in Houston, and one of the provisions of Magna Carta, I'm just going to paraphrase it, it said that you cannot be deprived of your property except by the judgment of your peers or the law of the land. What does that mean, the law of the land? There was this idea that there's some law that's greater than whatever the king's will is, right? You know, off with their head, right? Whatever the king says goes. But the idea of law of the land was there's some law that's above what the king says, that the king is not the absolute ruler. And that if the king takes some action, or a sheriff takes some action that's inconsistent with the law of the land, that action is invalid. When you see this phrase, due process of law, it seems like, oh, you get a procedure, you get a trial, you get a jury, right? That's only partially right. This phrase, due process of law, stretches back to the idea of law of the land. And what does law of the land mean? All exercise of power must be reasoned. All exercise of power must be reasoned. You must have a reason for doing what you're doing. You cannot merely act in an arbitrary fashion. What does arbitrary mean? At will, random, indiscriminate, right? You're just making stuff up. Why are you doing this? When the government takes action direct to your life, your liberty, or your property, it cannot be arbitrary. It cannot be random. There has to be some rationale, some reason, some law that justifies it. And what happens when the government takes an action that cannot be justified? You've been deprived of your due process of law. You've not been given the due process of law. Process, at least historically, does not only mean procedure. And that's actually one of the modern sort of contradictions. How can a term that speaks of process refer to whether a law is valid or not? Doesn't it just mean, oh, you get a jury, you get a trial? No, no, no. The idea of process means, is this law itself arbitrary or beyond the power of the legislature? Arbitrary power is based on will rather than reason. Everyone get that so far? Okay. If you want a cheat way to remember this, due process means what processes do, right? What does the process do to you? And you know what the process is? When the legislature makes a law, they must have some reason behind it. When the executive takes away your property or your freedom or your life, they execute you. You must have some reason behind it. I'll give an example. Oh, I'll do this now. I do this usually later. I'll do it today. Do you want to read the short story of the lottery? Yeah. Okay, don't give it away. Can I? Oh, come on. That wasn't that long ago. No. Oh, man. Okay, fine. I'll do the premise. So there's a short story called The Lottery, because you can't ruin it now. It's a good twist. Right? A short story called The Lottery. And there's this town. And everyone in the town is getting together, right? And I'm going to compress this story a little bit. And they all take a piece of paper out of a box. And the premise was that this town, I think there's a shortage of crops, so it's famine, people were hungry, and they have this ritual where they all go, everyone in the town, they take a little piece of paper out of the box. And one woman takes this piece of paper out of the box, and there's a dot on it. And they stone her to death. And the story goes, the way that they helped to deal with famine, with poor crops, was they did this lottery. And they would basically sacrifice one person to help the community have food. Now, why do I raise this example? I always ask this question. Was the woman who pulled the piece of paper afforded the due process of law? There was a process. Evan pulled a piece of paper from the box. And it was completely random, right? Fair. Impassionate, right? There's no one there. And if I remember the story, as she's getting pelted with stones, she said, it's not fair. It's not fair. What does fair mean? You know what fair means? Due process of law. That's what fair means. That even though there was a process that was administered fairly, I mean, no one cheated, no one stuffed the box, there's only one piece of paper with a dot on it. That this concept of due process means, is this arbitrary? Does it make any sense in any universe where if you stone a woman to death, you can help your agriculture? Of course not. It's ridiculous. But in that community, that's what they believed. So the question is, people believe lots of crazy stuff. How do you get to decide what arbitrary means? Well, my team absolutely, batshit, for lack of a better word, to us, right? Crazy. Seems completely rational to these people. Can courts decide what arbitrary means? Or is the very fact that the legislature adopts this law proof that the law is rational and not arbitrary? Who gets to decide? The judges or the courts? I realize this is class 18, but this is basically the entire crux of this class. Who gets to decide whether a law is constitutional or not? The legislature that adopted it? Or the judiciary reviews it? Think of McCulloch against Maryland, right? What did John Marshall say? That basically if the Congress, the very first Congress, those enlightened patriots decided this law is valid, who am I to say otherwise? Unlike in Marbury versus Madison, he says, well, yeah, the first Congress passed this Judiciary Act, but it's unconstitutional. Yeah, they can't expand mandamus. The legal tender cases, right? Who gets to decide if paper money is valid or not, the court or the legislature? The Missouri Compromise, Dred Scott. Who gets to decide this political compromise the parties reached to deal with slavery? And Roger Taney said, nah, it's not valid. That's an irrational law. It's a very bold act for a court to declare a law unconstitutional, especially because they're saying it's irrational. Now, at least in the first half of this class, we can ask, well, what does commerce mean, right? What does tax mean, right? There's actual textual cues for us to go on. But in this half of the class, what do we got, my friends? This. How do we know if you've been deprived of the due process of law? How do we know what liberty is? Oh man, we're gonna have fun with that one later. We want to talk about butchers, that's easy. We'll talk about abortion, that's a harder one, right? We'll talk about, much difficult stuff than just butchers and things like that.
We have an abortion debate next week, but that's not.
Very interesting joke about abortion and butchers.
No.
I thought you were gonna say. Thanks, Eddie. Okay, yeah.
We'll talk about the clauses it could go.
Yeah, the clauses. Anyway, where was I? Yes. So when you're in this entire scope of due process of law, and you're deciding whether law is rational, whether there's a reason behind it, that's beyond subjective. And what did I tell you? What was the very first case where the court invoked the due process clause to declare a law unconstitutional? Can you remember? Shout it out.
Jurisdiction. Supreme Court.
What case? No. What was the first case where the Supreme Court invoked the due process clause to declare federal law unconstitutional?
That's one of the executive power.
No. You're way thinking. I mentioned this case a few moments ago. Huh? No, not Crookshank. No, go back. Yeah. No, that wasn't due process. That was
Substantial due process clause with the one where they declared the Missouri Compromise.
what's the name of that case?
Dred Scott.
Tag team. Dred Scott. Why did Roger Taney think the Missouri Compromise was unconstitutional? Because it deprived slaveholders of their property without the due process of law. And he thought it was irrational that a person would merely lose their slave just by walking into a free soil territory. Yeah. That was substantive due process, the idea that it's not just about procedure, it's about the substance of the law. Yeah. So you might like substantive due process in some cases, but then you get to Dred Scott, it's like, whoa. This is one of the most controversial aspects of constitutional law. The idea that judges can decide whether a law is rational or not, whether there's enough reason for law. That the fact that the legislature passed law, that is not enough. The court must go further, or should they? Because they declare the Missouri Compromise unconstitutional. What about marriage laws? Laws about abortion, go down the list. Laws regulating contract. Laws restricting where butchers can work, can ply their trade. Now we speak of substantive due process about the due process clause, but let me tell you a secret, folks. The real basis of substantive rights is not really due process, it's PRI. These privileged immunities, these are the rights. But because of slaughterhouse, the Supreme Court just go whoop down one level. And they sort of pushed all the rights protected by PRI to due process. It's been this sort of this bait and switch. Now to be sure, due process, I think, does protect substantive rights. I do believe that. That's my opinion, at least. But the more textually grounded home for these rights, like the butchers and the Meyer Bradwell, the lawyers, is PRI. Everyone follow along. This is some deep stuff. I think we're making good progress. He's reacted.
Student asked me a question over the weekend. Are you gonna do the thing where you do the anonymous question asking stuff?
What?
Material at the beginning of the class, and you're like, if you have a question.
Oh, I stopped doing that. No one ever did it. Yeah, I used to do this thing. I stopped doing it. It was stupid. Where I would have it anonymous. It wasn't really anonymous. I would say, if you have a question, put it on the app, and like no one actually did it. And so I just stopped doing it. So I used to do it and I stopped. If you want, I can do it, but so few people did it, wasn't worth my time. I tried different things, but they don't work. I stopped doing them. And the guy watched your video from 2018. You did this thing. Yeah, I did in 2018. That's like 8 years ago, 7 years ago. It's a different world.
Student was basically asking if you could rely on Corey Field before, like, if that's something that they.
Corfield or Corio?
Yes. If they could rely on that. If, like, almost like if they could give a natural rights argument before we have the 14th.
Absolutely. All right. Okay, where was I? Okay, so back to these clauses, right? Now, what did the 14th Amendment actually do? It restricted the state's powers, specifically the state's police powers. Okay, and we discussed police powers, right? What is a police power? Broadly speaking, it's the power of the state to regulate the health, the safety, the welfare, and maybe the morals of the people. But you can't do that where it would deprive people of the due process of law. So let's just take Yick Wo, for example. Can the state protect the people from dangerous laundromats? Yeah, right. I mean, you may think of this for a minute, but having these large wood fires inside wooden buildings, maybe not the safest thing in the world, right? Having all these people slaughtering animals in their backyards and in their basements in New Orleans, maybe not the best idea for sanitation. So in those cases, at least, they asserted that these laws violated, that the police power went too far. All right. But let me give you another example. You're not going to like this one. I'll give it to you. Let's say the argument is, why do you need segregated rail cars? Oh, you ready for this? You're not going to like this one. The state says we're afraid that if people of different races are in the same rail car, there'll be violence. They'll fight. They'll create bloodshed. And the way that we protect people from violence is to separate them. Oh, I'll give you one more. Schools. We're afraid that people won't be able to learn in an environment where they're with different races, that they'll be distracted, that there'll be violence. And we need to keep the races separate to keep them safe. I'm not making this up. These are the actual arguments that were given in cases like Plessy and Brown later. If you want more, interracial marriage, we'll do this one in a couple weeks. Why did states ban interracial marriage? You aren't like this one. The government act, and this is actually on tape. This actually recorded in the Supreme Court argument. The lawyer said, children of mixed races will face such stigma and prejudice in their lives that we want to save them from that stigma. Don't laugh. It's true. This is what they said. And that we need to protect people and avoid these children from being made because they won't be able to function in society. That we're actually doing this for the children. That's why we ban interracial marriage. Now you're just going, oh my God, Judge, that's awful, right? Okay. So then that comes to the police power, right? Who gets to decide if the law is rational or not? If the government gives you a reason, is that enough? Or can then judges decide independently if that reason is good enough? And if so, how do you decide if a rationale is good enough? How persuasive does an argument have to be? Does a court even decide if this is the real reason? Maybe this is just what you might call a pretext or a lie. That they're not really interested in protecting people on train cars. They just want to create inferiority. They are creating the very racial conflict that they're seeking to avoid. How do you decide if a law is reasonable or not? Look at a case like Plessy. How much deference do they give to the government? They say, yeah, if the government thinks it's designed to keep people safe, well, that's good with us, right? Or Korematsu, right? In other contexts. Yeah, if the government thinks we do this to keep people safe from the Japanese people on the coast, yeah, we can exclude them. How much deference you get? Bank of the United States. Yeah, if Congress thinks this is valid, that's good. Obamacare. Yeah, if Congress thinks they need to mandate insurance, that's fine. Judicial review is a hard thing to do. It's very hard to generalize from one case to the next. Your head's probably spinning right now. Yeah. Yeah, I'm sorry. Stephen?
So all those examples you gave were, where the 14th Amendment was not, where they fell in line with it, or was that just like hypotheticals, I guess?
I don't remember what examples I gave. They're across the board. Some were valid, some were not. So for example, the ban interracial marriage was a case of Loving against Virginia from 1967 or 68, maybe plus or minus a year. They said the ban interracial marriage was unconstitutional. Then we have Plessy, where they upheld the ban on the train, they upheld the racial segregation in the train cars. My point is not even just about any particular case, is that the act of judging, deciding if a law is irrational, if it's arbitrary, these are very, very difficult human judgments that are not reducible. Again, the first half of the class, okay, commerce means something, right? We figure what commerce means, right? A tax is something, we can figure what a tax means, right? Commerce among the states, okay, that means something, right? But here again, I keep pointing at this wall, right? What does liberty mean? Abraham Lincoln, he didn't make it up, but Lincoln told this parable between the shepherd and the wolf, right? So imagine you're a sheep, and who's your biggest fear? It's the wolf. The wolf will eat you. So who protects you, right? It's the shepherd. The shepherd protects the sheep from the wolves. Now flip it around. Let's say you're the wolf, and you're really hungry, and you want to eat some sheep. If you don't eat sheep, you're going to die of starvation. The shepherd is your tormentor. He's the one who prevents you from living. That whether someone's your liberator or your tormentor depends where you sit. Right? So whose liberty are you speaking of? It's liberty is not so easy to define. Come with me. I'm not losing you. It's a good class so far. Okay. Then we get down to this phrase, equal protection of the laws. And this is the part that I think the fewest people actually understand. And then I actually, a professor at Mississippi, his name is Chris Green, opened my eyes in this. So I thank Chris very profoundly. The phrase equal protection of the law, if you ask most judges today, refers to, is the law being applied equally? Are white people being treated in the same fashion as Black people? Are men being treated in the same fashion as women? Right? That is not even remotely close to what this provision was designed to do. The fear in the 1860s was of lynch mobs. Think of the Crookshank case. Lynch mobs slaughtering innocent freedmen, just killing them. And then the local prosecutor says, yeah, we're not going to try this for murder. We're just not going to take anything. And even worse, the local sheriff may put on a hood and join in the fun, right? He may have been killing people also. You actually had this convergence of private and public actors engaging in acts of violence. And then the prosecutors refused to bring to justice those who engage in these heinous acts. And think of Crookshank, right? Where the federal government came in to indict these murderers for burning these freedmen alive. And what the Supreme Court say, no, you can't do that. Yeah, no, federal government can't do that. The protection of the laws meant that you protect people equally. That if you charge a person with murder for murdering a white person, then you charge a person with murder for murdering a Black person. That was the essence of equal protection. That however the law is being protected for one, you protect it for the other. And what's curious here is you talk about the state action doctrine, right? What's a state action doctrine? The state action doctrine is that the Constitution only regulates what the state actors do, what the people in the government do. But here it's the exact opposite. It's when there's acts of violence and the government takes no action, that's the problem. It regulates state inaction. When the state fails to prosecute, when they fail to protect people. It's almost the exact opposite of what people think today. But the Supreme Court is basically, this meaning has just been disappeared. It just doesn't even exist anymore. Right? Every case we study about equal protection of the laws, but oh, you're treating this like this and this like this, that's just not where it is. Which provision of the Constitution was meant to protect discrimination? Our good friend, the Privileges and Immunities Clause. Why? This protected the civil rights. And the Constitution says you cannot deprive any citizen of these rights. If the law says that, white people can go to this train car, but Black people can go there, you're depriving citizens of their rights. Almost every single segregation law should have been litigated under PRI. That was the home. That's where it should have been done. These were state laws, state legislation to protect people their civil rights. Strouder, PRI. Plessy, PRI. Civil rights cases, PRI. Those are all PRI cases. But because of slaughterhouse, you're stuck with sub-treasuries and navigable waters. That's why I sort of make fun of that, because this was the jewel. This was where you were supposed to have all these bases for taking state laws down. And the Supreme Court just said, no, we're not going to do that. Not even 5 years later. So again, talk about Plessy all you want, right? But we go back to civil rights cases and slaughterhouse. Yes, sir.
So now we essentially have a swing issues of privilege and immunity that take disciplinary action,
Yeah.
which is equal protection, or that there is a law
Mm-hmm.
that is depriving limits. Is that like what you're saying? That we have
Look, Sheldon, we'll do this in the next week or two, but I'm actually about maybe 3 weeks from now. The court doesn't think about any of these issues. They don't care about civil rights or political rights. They've just ignored that. They don't think about due process of law. Basically, the entire 14th Amendment was just basically jumbled together. It says, all right, is this law fair or not? Okay, we'll do it like that. The clause actually doesn't even matter much. But most of the work is being done with racial equality under equal protection, which is the last place it should be under. Now, I mentioned this last week, or maybe 2 weeks ago. I have no conception of time. I landed last night at 9:30 p.m. My clock is all off at the moment. But there were a series of cases involving the failure of the government to protect people. And there are 2 cases I'll mention them again. One was called DeShaney versus County of Winnebago. Who was DeShaney? Poor Joshua. His name was Joshua. He was a little boy that was savagely beaten. And this was a case where the police knew this child was at risk and they failed to protect him. And the family brought a lawsuit saying, please, why didn't you protect poor Joshua? And the court said, well, there's no obligation to protect people. They rejected that meaning. Another case called Castle Rock versus Gonzalez, 20 years ago. This involved, again, a woman who had a protective order against, I think it was her boyfriend or husband, I can't remember the details, restraining order. And the police were not enforcing the restraining order. And he engaged in severe acts of violence. And there was a lawsuit saying, please, why didn't you protect those restraining order? You had a judge saying, protect this woman from this restraining order, from this violent man. And the court again said, no, there's no duty to protect people. So the perversity is that the court is bastardized 14th Amendment. Like the stuff that's actually there, they ignore. And they put all this other stuff that's not there in there. It's just almost this weird perversion of the Constitution that I never quite get over, even though I taught this class many times. Did I answer your question, Shelton? Probably not. No, I don't think I wasn't going to. I wasn't going to, sorry. What other questions we have?
Was the power only apply to the state executive branch or also the federal?
Oh, wait for this one. So let's go backwards. If you remember in Korematsu, was it Justice Murphy said that this is just racism, right? That this is just smacks of racism. Remember he said this about the Korematsu case. And if you read Justice Murphy in Korematsu, he basically says that excluding people on the basis of their race violates equal protection of the law. Remember he said this? If you don't, go back and read your notes. But there's a problem here. So Addie asked about the federal government versus state government. The 14th Amendment has an equal protection clause. It's right there. The 14th Amendment doesn't limit state governments. I'm sorry, the 14th Amendment only limits state governments. It doesn't limit the feds. There is no equal protection clause that's applied to the federal government. There's none. There's none. So how could it be that the federal government is subject to equal protection? Ready for this? Reverse incorporation. Reverse incorporation. The idea that the 14th Amendment Equal Protection Clause jumped back 100 years, the Fifth Amendment, and that the Due Process Clause of the Fifth Amendment now is equal protection in it. Yeah, you're shaking your heads. And I'll tell you exactly what happened. Everyone knows Brown versus Board, right? Everyone knows that case. Yeah, states can't have segregated schools. there's another case we'll read about called Bowling versus Sharp. Bolling, Bowling versus Sharp. And this involved a school in the District. Oh, it's a good segue. School in the District of Columbia. As a segregated school in DC. You can't challenge a segregated school in DC under the 14th Amendment because it's a federal school. So what the court says, well, it doesn't really matter because the Equal Protection Clause of the 14th Amendment goes back to the 5th Amendment through the Due Process Clause. So basically the court said that due process of law actually means equal protection. It doesn't matter. It's whatever. It's got to go. It's the outcome. So all this stuff is so jumbled together. It's almost incoherent. You're welcome. But the part just for you to get now is that they've not focused on the text in any meaningful way. They've developed all these other doctrines that we're sort of grappling with now 200 years later, 150 years later. You look troubled, confused. You look really troubled. Yeah. Yeah, 1 second, just yeah. I'll get you a second. No, Equal Protection Clause does not apply to the federal government. Okay. So what's curious, okay, so in Article 2 of the Constitution, something called the Take Care Clause, which is that the president has a duty to take care of the laws are faithfully executed. It's actually a very difficult question that I don't even have a clear answer on, whether the Take Care Clause imposes some duty in the executive branch to protect people. Now, this is Josh speaking, this is not any sort of court speaking, this is just me speaking for a moment. I don't think you actually need an Equal Protection Clause. I think the very nature of government is provide protection. That's why we have government, right? This is in the reading Locke, right? This never actually happened, but just suspend disbelief, right? People were in this state of nature, right? They were running around, killing each other. It was very violent. And they said, wait a minute, this is no way to run a show, right? My property is being stolen, people are killing me. Let's make a government and let's give our own power to use violence to this government to protect us. And that way the government protect us. The very reason why we have government is to protect people equally. That's why government exists, right? We don't need government, right? We don't need it, but it's to protect people. So in my view, to Paulina's question, I don't think you need a 14th Amendment, right? I think the 14th Amendment just stated what was already obvious. It was stated what was already present. It wasn't being enforced because southern states were abusing it wildly, but those were governments that were not actually engaging. I'll give you one more. The guarantee clause in Article 6, where the Constitution guarantees a state's Republican form of government. That doesn't mean like, GOP, right? That means a representative republic where people are being protected. So I don't think you need an Equal Protection Clause. I think it's there. It's nice to have. But for a government to fail to protect people, that's why it exists. Like that's why people give their I can't just go down the street and say, you know what, you wrong, I'm going to shoot you, right? I can't do that because we have a government thing that we have processes to resolve conflicts. Does that answer your question, Paulina, or not? Interesting. Oh man, I got interesting. Kelsey, I passed over you a minute ago.
Arbitrary, like in the Plessy case, they were talking about mixed race and how do you determine a mixed race?
Oh, yeah.
Yeah. Is that based on state law? Is that based on judicial scrutiny according to state law? Like how do, and I know that's the question you're asking, but I don't think we've got to the answer, right? Because I'm kind of.
I want to answer your question a little bit now. We'll get to more of it later. So when you're asking about whether a law is arbitrary, we think of a racial line. The southern states had extremely detailed lines based on race. It was almost like a precursor to Nazis, right? How many Black grandparents did a person have? Were you, we use words are not pleasant, a quadroon, an octoroon, right? 1/8, 1/4, there were entire categories. Mulatto, these were categories meant. Could you inherit property depending how many Black relatives you had? They actually had very elaborate racial codes based on how much black blood a person would have. It's basically a precursor to Nazism. I'm not exaggerating too much. Right. I mean, the Nazis got a lot of stuff from us. They didn't invent that. They got a lot of stuff right from here for us. So is that stuff arbitrary? You bet it is. You bet it is. But that's me saying this here in the year 2025, right? Can a judge tell an entire state legislature that's built up this elaborate racial code that they're being arbitrary? That's the harder question, right? Yeah.
So, like, the locking period really is, and this is in consideration of like, our exams, that the midterm was in.
The midterm, okay, I forgot about that. Yeah, go on.
The locking period is the basis of, like, each protection without it explicitly being stated. But in that, in conjunction with the amendment, would be the basis for equal protection, either prior to.
I think so. Again, this is Josh speaking. This is not any sort of court speaking, but and my colleague Randy Barnett's one of the experts in this. I mean, arguably, we don't need a Bill of Rights, right? The Constitution was framed without a Bill of Rights. We didn't have a due process clause. Did that mean all of a sudden that the government didn't protect you? I don't think so. Right? They added Bill of Rights kind of like to make sure it was clear, but the Bill of Rights merely stated was already present, right? The idea that there were these certain rights, free speech, free exercise, and so on, that you didn't need to write them down, but they decided to write them down. And maybe that was a mistake. I mean, look, the anti-federalists opposed the Bill of Rights because they said, look, if we write this stuff down, those are the only rights we have. We don't want to do that. Steve, what's your hand up?
Hi. Yes, so like, in all these cases that we've been doing where we're saying like this, like discrimination, like doesn't fall into privileges or immunities clause. Are we saying that it falls, like the better argument is for equal protection because it's like some citizens are being treated differently than others?
It's either PRI or equal protection, but the key point is there actually a civil right that's being deprived, right? Accessing common carriers, public accommodations, those are privileged means of citizens, right? This is what Justice Harlan wrote in the civil rights case. I think he's right about that. I think the civil rights case is probably the worst Supreme Court decision you've never heard of. You'll hear about Plessy, Dred Scott, civil rights cases, and Prigg, right? Prigg and civil rights cases are far worse than Plessy and Dred Scott. I will take that one to the bank. I think I'm right about that one. Prigg was one of the worst you've never heard of, and civil rights cases even worse. There was Congress saying we want to protect these rights. Of course, no, you can't do that. You can't do that. That the deference given to Louisiana legislature in a case like Plessy, the exact opposite of the deference given to Congress, the Civil Rights Act of 75. Right? The court was not being consistent with being deferential. All right, go with me. I think I did everything I want to do with these. These are good. All right. This is deep. I don't always do this, but I think you guys are sort of ready for it. So every semester is a little bit different. Watch this class from last year. I didn't do this stuff, but I think you guys are ready for it. So I take it as a compliment, if you will. All right. Let's do Yick Wo. I don't know where the heck I am. You remember? You've been dreading this for like, and then William, which way am I going? Okay, so Brenda. All right, Brenda, thank you, ma'am. I appreciate your honesty. One year, no one ever raised your hand. I was like, no, not me. So Brenda, let me ask you a question. Let's give you an easy one. All right. The facts, please, in Yick Wo, if you could.
In San Francisco, there was like a laundry place owned by a Chinese person.
Okay.
And from my understanding is like they required like registration or like a certificate of approval or something like that to like run their business. And the first year they were fine.
Right. So why? Just I think I mentioned this point before. I'll say it again. Why might the government have an interest in regulating laundries?
Like you said, if it's the building is made of wood and got fires and.
Yeah. I mean, just technology for a minute, right? How did you do laundry back in the day? You needed hot water. And how do you make water hot? Don't laugh. You need fire, right? There's no electric heater, so you'd have to heat. They had these like huge pots of hot water. I mean, like these ginormous vats of boiling water, and they would use that to clean the clothes. And those involve, I think, either wood or coal fires. Just using common sense for a minute. If you have wood burning inside of a wooden structure, everyone just agrees, a nod, that might be a problem, right? Now, it turns out that in this case, this was done safely, and the defendant in this case, Yick Wo, his name was actually Lee Yick, had operated this business for many years. Now, William, let me ask this question, make sure I'm asking this question right. On what basis were the permits granted? This is an important point.
Like,
What did you have to do to get a permit?
you needed the permit if you were using,
No, you're correct. You needed the permit to run the laundry. My question is a little bit different. On what basis were the permits issued?
there was no basis, like, it was a neutral law that.
Wait a minute,
Yeah,
what do you mean there's no basis? You gotta give me more.
Yeah, I mean, I thought the ordinance was like a race neutral.
Well, forget about race for a minute. Were there any inspectors that came by and saw if your facility was operated safely?
Oh, no, I don't think so.
Did they inspect to make sure that you had training, that you knew how to operate the line? Was there, maybe they checked the ventilation, that you had enough, fresh air coming in?
Oh,
Then what the heck was the point of this permit? Well,
I think it was to create a monopoly, but.
so everyone see the issue here, right? Everyone, I think, would agree, that the government could decide under the police power to inspect, to make sure that the equipment is safely operated, so that people have training, to make sure that maybe whatever equipment you're using is up to date, right? That's not, damaged ovens, that there's ventilation. Everyone agrees on that one, right? But here, the ordinance was basically you apply for a permit and we give it to you if we want to give it to you. Now, William's correct. There's nothing in the law that speaks of race. Nothing, not a word about race in the law, right? There's not like the Plessy case from a few years later. The law says you apply for a permit and we'll give it to you. And in fact, Mr. Yick Wo had gotten the permit some years earlier. But then all of a sudden they didn't give it to him. All right. So then the question's this, Michael, I'll come to you. Which provision of the 14th Amendment does this San Francisco law violate?
Due process and equal protection.
Both. Tell me how. So let's start with due process. How does the San Francisco law violate the due process of law?
Because it kind of just gave a, I don't know, like authority without principles, really.
Oh, I like that. What do you mean authority of the principle? It's a nice way of saying it. What does that mean?
There's like no guidelines.
What's that word we use when power is exercised without any guidelines?
Arbitrary.
Yes, sir. It's arbitrary. I asked William this question a minute ago. He gave me, I think, a good answer. On what basis are the permits issued? None. No basis. They give it to you if they want to. This is the very definition of arbitrary power, right? Based on the will, the discretion, the caprice, the random beliefs of whoever's in government. Maybe they're asking for a bribe. Maybe they don't want to give it because they don't like Chinese people. Maybe they want to give it because they like this other guy have a laundry on down the block. They want to create a monopoly, right? There's no actual standard by which this power is exercised. There's no reason. So most people only see this case as equal protection case. But that's not how the court describes it. And you can look at this in the reading. The syllabus describes it very clearly. This is about arbitrary power. No discretion, right? No, it doesn't matter whether the person's competent. It doesn't matter if the equipment's safe. It's arbitrary. Yes, Fidel. Okay, we're switching topics. Okay, so I had to pivot for a second. We're not talking about lunch, I'm talking about president removal. There is an argument to be made that all power must be exercised with some reason. There is another argument that some people assert that when you have the executive power, that you don't have to have any reason, or more precisely, the reason is because the executive thinks it's so. So when Congress creates an office, they might say, you must give some rationale why you remove the officer. I don't think it's ever been argued that, well, it would violate the due process of law to remove without any rationale. This is one of these areas where Article 2 and Article 5th Amendment maybe conflict, but it's my thought. Good idea. All right, where was I? All right, so without question, this law was viewed as perhaps unconstitutional under the Due Process Clause. But Jake, what's the argument that this law also violates the Equal Protection Clause? Right, so who is getting protection under this law? And who is not getting protection? Was the law protecting people equally? That's right. You can substitute the word protection for enforced, if that makes your life easier, right? The law is not being enforced equally. That some people, the white launderers, were getting their permits. And others, the Chinese launderers, were not getting the permits. This was a violation of protection. But the key point is, it's not that they treated whites and whites and Chinese people differently. The law is not being enforced. They were not granting the permits on equal basis. Everyone sort of get the gist of this case. Now, you might ask yourself, wait a minute, John. This is a poor laundry worker in San Francisco. How the heck did he appeal his case to the US Supreme Court? Did anyone think that when they were reading this case? Maybe not like me, but I was thinking, like, how did this poor guy who washes, sheets get his case to the Supreme Court? And the answer is this case was not supported by just Mr. Yick Wo. This was a test case. A test case supported by the Chinese government. And what do I mean by a test case? They wanted a way to stop this sort of anti-Chinese hatred in California. Now, by the way, when you get to Korematsu, you think, oh my God, how could the people in California and the West Coast hate Japanese people so much? This wasn't new. You don't talk about this much today, but the hatred of Americans towards Chinese immigrants was really strong. And in some regards, even stronger than those against Black people out West. You don't talk about this much. There were entire laws banning their migration. What does Justice Harlan say in Plessy? The unfortunate race. Remember that line? That was completely out of nowhere. Like, whoa, where'd that come from, right? Go Harlan, go. What? Right? It just kind of hits you like a pound of bricks. By the way, most case books don't include that line in there. No, we do. We include the good stuff and the bad stuff. Someone at a hand, Stephen.
I was wondering, when did strict scrutiny start applying reviewing laws, like based on race?
The term strict scrutiny didn't come into existence like the 1960s. Right? I mean, Brown might be the first such case. I mean, actually, to be precise, I'm wrong. Korematsu said, and I'm paraphrasing, I don't have the exact quote, that racial classification must be reviewed strictly, or maybe it was stringently. So Korematsu hinted at strict scrutiny. I don't think it used that label, but that was the first case they kind of hinted at that. So Korematsu was what, 43, 44, so I guess around then. But anyway, yeah, so the Chinese government wanted this test case because you had an entire class of people who were immigrating who were unable to work. Right, and they're being excluded from a very common business that the Chinese people were doing, which is laundry. Yeah, there were actually several cases. Again, Yick Wo was actually arrested. He was thrown in prison. This was not like, say, oh, we go to federal court, we sue on a law. No, this guy actually was incarcerated for failing to comply because he wouldn't get his permit. All right. So let's walk through the analysis. Ted. Why does the court think that the San Francisco ordinance is unconstitutional?
Well, other than that, they believe in violating.
Well, why? Why did violence protection? Question.
The ordinance was neutral on its face, but when it was enforced, it was enforced differently based on.
Well, you're right about that, but does the ordinance on its face have any rationale for why people would not get this permit?
No, it's just like a check the box kind of permit.
What do you mean check the box?
Bureaucracy, I think.
Oh, bureaucracy would be good, right? You might hate bureaucrats. Bureaucrats are doing something deliberate, they're following a process. Is there any process or protocol by which the permit can be granted?
No.
Yeah, I know it's often pejorative. Oh, you're a bureaucrat. Well, a bureaucrat's not just making stuff. There's some checklist, right? There's some protocol. You do this, you do this, you do this, you get your permit, right? There's some process laid out. They describe these as tenants at will. Anyone notice that? Like properties are tenants at will under the supervisor, and they can't have any say. This is merely an arbitrary line. Okay. Now, the court says that nothing in this law is about race. And the 14th Amendment, the court says, is not limited to citizens. Privileged immunities is about citizens. But due process, persons. Equal protection, persons. That matters. By the way, this is a reason why some people today don't like PRI, because it will be limited to citizens. This came up in a case called McDonald v. Chicago about 10 years ago, that if we reinvigorate PRI, would people who are not citizens get these rights? And the answer is probably not. And that makes me feel very uncomfortable. But the answer is the text is there. It's there. Citizens have certain rights that non-citizens don't, as we're seeing quite clearly in the litigation today. All right. They reference the Massachusetts Constitution of 1780. This is a very important document drafted by John Adams. And it speaks of a government of laws, not of men. And this idea that we have some law above the arbitrary will of man. Okay. And then the court gets to this very famous passage. I just want to read some of it for you. The court says this is a law that's directed a particular class of persons. And they say it's a mind so unequal and oppressive as to amount to a practical denial by that state of that equal protection of the laws. Okay. The court says the law itself is fair on its face and impartial in appearance. In other words, the concept of race appears nowhere. The law doesn't say Chinese people do not get a permit, right? That'd be a very different type of a law. The law is neutral on its face. But it's applied with an evil eye and an unequal hand. An evil eye and an unequal hand. Chanel, help us out, please. What does that mean? An evil eye and an unequal hand. Very, very, very powerful language. You don't usually see good language in the court opinions. What's that going on?
For health and safety, but it's actually because the race is inflicted.
What does an evil eye mean? Good. Yeah, the intent, right? It's you're saying one thing, but you're doing something else. An unequal hand is that you're not applying this all evenly. That if a white person comes to your office, you give them a permit. If a Chinese person comes to your office, you're denying it. And this creates the idea of what you might call pretext. I think Chanel spoke to this a moment ago, where the government might come and say, we're doing this for reasons A, B, and C. But Chanel says, no, that's not the reason why you're doing it. The reason you're doing this is you guys are a bunch of racists, right? You just don't like the Chinese people. has a court decide if people are lying to them? Or maybe they're not lying, maybe there are multiple rational, maybe they really do think A, B, and C are true, but they're also opposed to Chinese people having these positions. Maybe they think that these jobs are reserved for Americans. Called a tariff, right? We're trying to keep jobs for American citizens. Is that rational? We have lots of laws that limit occupations to American citizens, or I can tell you a lot of them. I mean, even in this building, right? If you're a foreign student, you can't be my research assistant. I'm sorry, you can't. I can't hire you. It's not because I hate you. I don't want, I have no. Just the government doesn't let you work as a research assistant and work study if you're a foreign citizen. How do you decide what the real motivation? How do you decide the eye is evil? What does an evil eye mean? People often act with very conflicting rationales. They have many reasons why they do things. How do you look at a statute and decide what the legislature intended? Here they're clear, right? The numbers are pretty overwhelming. What was it 200 something? I forgot the numbers, right? No permits were granted to Chinese business owners, and only one Chinese person was denied an applicant. Those are pretty good numbers, right? You usually don't have numbers like that. But let's say the number is a little bit different. Let's say that half of the people who were Chinese got permits, half didn't. Let's say it's a quarter, 10%. Well, pick a number, right? Or is it that because there's no rationale, you presume the evil eye? That there's no basis in which any permit's denied is a presumption that it is. How do you decide? Yeah, Shelton, then Trent.
Oh, I think you were getting at what I was
Good.
about to ask is, if there was some kind of basis, that we really explain, like, we want Americans to do it, or we want American citizens to have the first reading. But there are some people who get it, and we're evaluating it based on outcome, which seems like where the court moved. Where do we draw the line in our?
Well, then maybe it's being, I mean, just respond to Sean's question. Maybe the law itself, in fact, is neutral. We have a really bad guy executing it. Maybe it's a bad sheriff. Maybe the problem is not the law. Maybe the person's executing it. Why don't you say, okay, to hire someone else?
That's what I'm asking you.
This is a very common theme where the government will say, we're doing something for reason A. Right? To Fidel's question a minute ago, I'm firing this guy because of reason A, B, C. And the court says, no, it's not. You just want someone else. Well, maybe that's true. Maybe there's multiple rationales, right? People have what they call a mixed motive. You hear this phrase a lot, mixed motive. People are we're all complex, right? If I ask you, question, why did you go to law school? I actually ask most people that question, like, why'd you go to law school? The answer is never clean, right? There's usually a lot of reasons, and maybe you're gonna tell me the real reasons, right? No. Why do you do what you do? Why are you pursuing this path? We're all complex. I don't have a clean answer for you. Yeah, 1 and 2, go ahead.
There's like, basically, in order to determine whether or not it's quote arbitrary, they just look at the trial court record, right? That's about all you can do.
Oh, boy, trial court record.
So you hope that if you're trying to advance and say it's not like discriminatory, you basically try to give all your rationale to the trial, right?
Yeah, but how do you know? I mean, maybe it's the case that this government decided they want jobs reserved for Americans. America first, right? Make San Francisco great again, right? Maybe I'm being facetious, but I'm not, right? How do you know that those are not the real rationales? Or I mean, again, go to Plessy, look how deferential they are to the government, saying, look, they want to protect the race, it's where race wars on the trains. Is that irrational?
It's like basically like that's like basic. They can only review the records, so they basically.
Courts are not limited to the records. It's a lie. The Supreme Court routinely, it drives me bonkers, routinely looks outside the records. Yeah, 1, 2, and 3.
Is it not similar to how the court applies the Commerce Clause in like the legislature?
What do you mean?
Like, in some cases, they're like, oh, well, I'm gonna put this legislation through and say, oh, well, this is because, this is the reason why we're doing this, but it's really another reason. And sometimes the court is like, this is way too far.
Okay, so why is this? Why are they making by health insurance, right? Why are they regulating locally grown wheat? Is this the real reason or something else? You guys are now sort of inching closer to the idea of what judicial review is. Where the government says, here's a rationale, the court says, no, it's not. That's when you get, poor Matsu, right? We're doing this for national security, and the poor Matsu says, no, he's a bunch of racists, right? You like Japanese people. And you know which one's right? Judging ain't easy, right? Being a judge, I know I rip on John Roberts a lot, and maybe I shouldn't be so glib, but it's not an easy job. I think they make severe mistakes on a daily basis, right? But it's a thankless task. Yeah, Fidel, and then I'm sorry, Oscar, then Michael. I'm sorry. Yeah, do it again.
I think this rivals Korematsu in a lot of ways, where it's about the context in the area of what's going on, right? Because like back then they could have seen it as like the same thing, like make like America first again, like maybe the Chinese immigrants were taking a lot of jobs.
They took her jobs. Yeah. Yeah. Michael's your hand up?
Yeah, I mean, I guess I was just asking, like, don't they, like, really get more insight from the, like, AMICUS briefs? I don't know how to say the word.
Oh, amicus.
Yeah.
What's an amicus brief? Do you know?
Yeah, it's like just, like people who kind of have certain opinions about a cause.
Right. So so amicus, like amigo, right? Friend of the court. So anyone can file a brief for the Supreme Court. I file them all the time. I'm sure they're ignored and shredded as soon as they get my briefs. Like Blackman's brief shredded. Yeah, a little like a voodoo doll with my face on the Supreme Court chambers, I'm sure. They put pins in it whenever I blog about them. Wait for later today. The court often uses stuff that's outside the record, and I'll give you one more. On occasion, the Supreme Court will have a case where the government declines to defend the judgment. They say, you know what, we think the lower court got it wrong. And the court will actually appoint a lawyer to argue on behalf of no one, right? The court appoints a lawyer saying, argue on behalf of this decision that no one supports. I think it's unlawful. I think it's improper. The court does a lot of funny business, and they do. It's good to be the king, as Mel Brooks would say.
So you're saying that we're inching to understanding what judicial review, is that mean?
Now, after 18 classes, you're almost there. You think you got in class 1? No, you didn't.
Is that saying that judicial review is behind the intent behind whatever is up on his face?
I'll say it like this. There's some cases where judging is easy, right? What does, commerce mean? What does, tax mean? But even then it goes a little deeper. So for example, United States and US versus DeWitt, right? There's a case about oil. If you remember, the rationale in the case is, why were they trying to tax this oil? Was they were trying to stimulate the sale of some other kind of oil. And remember, Chase said, that's not the reason why you're doing it. It's you're just trying to regulate a local activity. You're trying to just raise revenue. And the court basically said that's not the real rationale. So we've seen here and there in cases where the court says the rationale you're giving is not the real rationale. And that's when you start getting into the sort of very zone of twilight, if you will, this very, very, very hazy area where the judge is saying to legislatures, no, we know better. It happens all the time. Everyone does it left and right. But now I think you're kind of seeing it. Yes, Abby.
But on the exam, you'll put them in a time period, right? And they will be constricted to those cases.
Sure, why
So
not?
they don't need to come up with their own,
You will.
the one right answer, except for really in the one area where you kind of give them a chance to express their views.
The principles I'm speaking of are timeless. I mean that sincerely. These are timeless principles. They don't have, I mean, sure, there are cases you can or can't cite, and I think it's a fair question you asked, but these are universal principles. Go to any country in the world where any court decides if a law is constitutional. I mean, I was just in Israel. Israel doesn't have a constitution. They don't have a constitution. They never adopted one. And at one point, their Supreme Court said, you know what? These laws, we're gonna pretend this is your constitution. And then Israeli legislature tries to amend those laws. And no, you can't amend those laws because it's unconstitutional. Even though there's no constitution. That they tried to amend the law that they said was the constitution, and they can't do that because that itself is unconstitutional. You think our country's screwy? Go look at the Israeli judicial system. It's a mess. It's an absolute mess. Yeah, they don't like me. I got into a big argument with some Israeli law professors last time I was there. It was not pleasant. It's okay. I'm safe back in America. No missile sirens here. A missile siren went off 20 minutes after my class finished last week, so you guys were safe. That's fine. But I did, like, okay. Yeah, yeah, yeah. They're missiles flying from the Houthis from Yemen to Israel on a regular basis. Yeah, one of those. Yeah, you have to go hide in a bomb shelter for a bit. Yeah, no, hypersonic missiles. They can reach Tel Aviv like in 2 minutes. Yeah, the siren went off about 20 minutes after class finished. I was like, oh, please don't do it in class. But I'm going to keep teaching. I'll bring my computer to the shelter. I've done it. Assuming there's Wi-Fi. We'll travel. All right. Where was I? Okay, so again, evil eye, unequal hand. Okay. The court says that there's no reason whatever, except for the will of the supervisor, why they're denied a permit. That everyone who's white gets a permit and everyone who's Chinese gets denied. There's no reason. It's illegal. And this is a violation of both due process and equal protection. Yeah, go ahead.
X, Y, and Z is appropriate for our state, and we don't need a rationale other than. Isn't that the point of the police power?
Oh boy. All right. So this concept of police power is very contested. The Supreme Court has never given any conception what the police power is. It's something I've given a lot of thought to over the years. And that's why I always say health, safety, welfare, and maybe morals. Because when you lump in morality to the police power, it's a very different world. What's the power of the state to protect morality? Ban different kinds of sexual relations, maybe. Say that illegitimate children can't inherit property. We want to encourage marriage, right? Limit divorce, right? Prohibit pornography, obscenity. What's the police power? These are not easy questions. In what are you gonna say? In Yick Wo, the court is very skeptical of the police power of the state. Yet only a couple years later in Plessy, it's the exact opposite. And they say the state has a police power to protect the rails, and that's it. It's very hard. That's why I teach these cases back to back, Plessy and Yick Wo. It's a challenge to reconcile these two cases. It's almost like different courts. They've decided so close in time. Yes, Bobby.
So for the, I know we still have like the bill of attainder and ex post facto.
They're in the Constitution, yeah.
So why, I mean, this kind of seems like you're enacting laws to target a certain group of people.
Right, so to be clear, ex post facto means you can't criminalize something after it's done. So imagine today the speed limit's 65, and then tomorrow say, no, actually the speed limit yesterday was 55. That's ex post facto. A bill of attainder is a law targeting a specific person. So it says, Bobby McGinnis is a criminal statute passed. That's a bill of attainder. This is not a bill of attainder. It's a law that maybe neutral in its face, but that does have an effect on people of particular race. So I don't think bill of attainder and ex post facto are really relevant here, but good point. It's funny, in the TikTok ban, one of the arguments was that the law was actually bill of attainder because it's targeting only TikTok, and that argument didn't really go anywhere because this wasn't a criminal law, it wasn't punitive, so that didn't really apply. But the law is definitely targeting one company alone. All right. Other questions on Yick Wo? We can move on to Plessy. Oh, my camera's wigging out. I don't know which way it's going. It's going every which way. I like this camera, but I don't like it. So I'm very, very. Look at this. It's going up in the ceiling. It's probably it's AI. This thing gets a frame of mind of its own. Like decides like, oh, I want to look over there. Okay, there it is. It's returned. Okay. Any questions for the Plessy? Okay. Lauren, you next. You've been waiting patiently. All right. You want to give me the facts, please, on Plessy?
Requiring all trains to have like separate but equal accommodations, but basically by race. And then Homer Plessy
took a seat on like one of the sections on the train reserved for white people. And so that he was ejected by a police officer, and then because he refused to move to his section of the train. And then, yeah, so he got arrested.
Okay, very good, thank you. So I'll go back to Chelsea's question a few minutes ago. I promise you I'll come back on this. So we don't have a photograph of what Mr. Homer Plessy looked like. If you Google it, you will find photographs. It's not him. It's actually, it's a problem. There was another guy, oh, I can't remember his name. He was actually in Louisiana. He was actually in government. And if you Google Homer, just try, if you Google Homer Plessy photo, you'll find one. It's not him. There's no known photograph of what the guy looks like. We just don't know. Another thing, there are several graves where he's buried. We don't know where he's actually buried. There's probably one that's probably the better cemetery, but there actually are several graves. Like, here lies Homer Plessy, right? So we actually don't know where the guy's buried. So we don't actually know what he looked like. The accounts are, and this is, you know, not perhaps appropriate to say, but he looked white, right? He looked white. As you say, he could pass, right, for a white person. And he was selected very deliberately as a test case, the same way that Yick Wo was. They wanted this to be the guy who I think is 1/8 black. I just, you know, maybe one was that one grandparent, one great grandparent. I can't remember. My math is not that good. Yeah.
I thought you said a Yick Wo use like there's a test case by the Chinese government.
Oh, it was, yeah. It was. In this case, this was a test case by civil rights groups in the South. They wanted a guy who looks basically phenotypically white to be the plaintiff, or actually criminal defendant. And we know there's a test case because, was it $500 bail? Right? Most people in that time did not have $500 just sitting around in a pocket. Right? That's not something the poor black guy would have had just sitting around. So this was sort of a setup. Yeah.
Do you think the train was like tipped off about what was going to happen?
I think probably was a setup. The train companies didn't actually want this. Why? Those extra costs for them. Who the hell wants to maintain two separate train cars? Right? Imagine you have one entirely empty black car and one cramped white car. You want just to spread the password, just distance, right? You want people to sit where they're empty your seat. So this is actually in the case. The train companies didn't actually want this. And this is also different from the civil rights cases, right? In the civil rights cases, these businesses wanted to segregate. But here, the businesses did not want to segregate. It was the government. It was the government that mandated the separation. So, oh, nice, Anna. Perfect. I'm right. We're staying in the right spot. So, Anna, let me ask you a question, right? The Civil Rights Act of 1875 banned segregation in place of public accommodation, right? Is a train, would everyone agree? You agree that a train is a public accommodation, common care. We agree on that, right? All right, the civil rights case also said that the problem with the law was that it only applies to state action and that these private businesses could segregate. Is there state action in Plessy, Anna?
I would argue that there is.
You bet there is. There's a state law in Louisiana saying you have to have separate train cars. My question for you, Anna, maybe you know the answer. Why wouldn't this law, this Louisiana law violate the Civil Rights Act of 1875?
I think they said it in a really not good way, that it was basically because it was equal, it was not putting.
You're talking about the Constitution, I'm talking about the statute.
Oh,
Why, the statute specifically says you can't have segregation in place of public accommodation, and that applies to state action. This state action, why wouldn't this Louisiana law violate the statute, Civil Rights Act of 75?
I would say that.
The statute.
Can you rephrase?
Why wouldn't the state law run afoul of the statute, the Civil Rights Act of 1875? Not saying go on. Lauren?
I think, was it maybe because it could be called like a reasonable exercise of police power?
Damon?
You can describe it as like a legal distinction.
Steven?
So that the discrimination didn't rise to be, bad, like it was, they basically said like it wasn't.
No. Trent?
So the 1875 civil rights act was unconstitutional.
Ooh. Karen, you had something?
That it was more so like corrective legislation and where there was nothing to.
Kind of, so. This is a part that like no one actually understands, and this is shows how sort of bankrupt the Supreme Court was at this point. And I think these were bankrupt quite deliberately. Congress passed a law, the Civil Rights Act of 1875, that says you can't have segregation in places of public accommodation, like trains and railroads and the like. The Civil Rights case says, aha, you need a state action requirement, right? You can only have this law enforced if there's government segregation, not this private segregation. So then you get to Plessy, you have government segregation, you have state action. What does the Supreme Court say? Well, that law was declared void, so we don't have to follow it anymore. What did I tell you guys? Courts do not strike down laws. They can't. They can't just erase a statute from a book. They can't do that. All they can do is say, we cannot enforce it in this particular case. It's all a court can do. It's not, they're not God. They're judges. Trust me, they're not God. We see the problem. If you believe that courts can strike down the statute, then it's as if the Civil Rights Act of 75 doesn't exist, even where there's state action. You see that? Even where there's state action, they say the law doesn't exist anymore. It's void. Nonsense. Plessy proves this point. So Anna and a couple others, like, hold on, you all. The correct answer, right? The correct answer is that the law itself remained valid. And it should have preempted the state law. Everyone see that? So all this stuff in Plessy was almost like a distraction, right? Because Congress had already banned the very thing that he tried to do. But because of civil rights cases, you never got there.
You can argue that they should just revisit. Like,
Civil rights cases?
yeah,
Well, remember I gave you the reading last week in Morrison, U.S. against Morrison. The court reaffirmed Morrison. The court reaffirmed civil rights cases. I'll blow your mind. Part of Atlanta Motel. Right? If the Civil Rights Act of 75 is still in the books, why do you even need it? Part of Atlanta. Go to section 5. That's what Justice Douglas said in Heart of Atlanta. Everyone with me? So this is really more about federal courts than about the Supreme Court or constitutional law. But this myth that the court struck down the law in civil rights cases left Plessy open. Most people do not get this point. It's actually somewhat of a obscure point. Sure. The myth that the court struck down the Civil Rights Act of 1875 in the civil rights cases allowed Louisiana to do what it was doing. All right. So let's walk through this case. Again, Homer Plessy boarded the white train car. He was arrested. By the way, who's Ferguson? Plessy versus Ferguson. Ferguson was the judge who issued the criminal sentence. It's a weird quirk of Louisiana law, where if you want to challenge your conviction, you basically sue the judge. it's a weird thing. I don't know any other state that does like this. Louisiana, everything's kind of different. But Ferguson was the judge. I actually found Ferguson's obituary. It was in the Times-Picayune, the New Orleans newspaper. And you would think the most famous case in like Supreme Court history, it might be mentioned as obituary. It wasn't even mentioned. Because it wasn't even that big of a deal back then. By the time you get to Plessy in the 1890s, segregation was already taken a hold. Right? This was again the last stop on the train, not the first stop. So his obituary didn't even mention this. Sort of a positive sort of anecdote. Their descendants are still alive today. So there's was it Keith? Oh God, that's his name. Keith Ferguson and Phoebe. No, it's Phoebe Ferguson and Keith Plessy. There's a photo of them in their book. They founded a group called the Plessy Ferguson Foundation. Who was it? Was it? I think it was. Oh God, I'm blanking. One of them actually found my lectures on YouTube and was emailing me about stuff. That's kind of cool. They found my lectures about their case. They were like talking about it. But it's kind of a nice salve that years later they were able to come together, even though their ancestors probably were not very good friends. All right, so let's walk through this one step at a time. So the first question is, does Louisiana's law violate the 13th Amendment? Damon, I'll just come back to you. Does Louisiana law violate the 13th Amendment? Yeah. That's right. We have this line, I think it was Alexandra that read it for us last week, that it runs the argument to the ground. Remember this one, Alexandra? I think that was your line from, I remember. It was a good answer. That it runs slavery question to the ground to say that everything's slavery. And frankly, this was already established. This was not new. They cite the civil rights cases. So again, you have these precedents which let Plessy happen. Plessy was not written on a blank slate. So they'd already gutted the 13th Amendment. That slavery just refers to involuntary servitude. And they say something that might have surprised you. I always kind of get a little shook when I read it. It says, statutes that imply legal distinction between the right and colored races do not destroy legal equality. Wait, what? What they're basically saying is, even if the law treats you differently, you're still legally equal. That is, whatever legal rights you have exist, even if the law sees a difference. And they say something also that I want to just pause this for a minute. They say, the distinction which is founded in the color of the two races must always exist so long as white men are distinguished from the other race by color. In other words, race will always be here. And there will always be distinctions in the law based on the race. What the court said in modern times is that any sort of distinction based on race is arbitrary. There's no reason to ever distinguish people based on the race. But that's a 20th century conception of what arbitrary means. In the 19th century, where to Chelsea's question, you had all these very detailed classification of how many black grandparents you had, that was very important to them. It was not considered arbitrary. That was a very important part of their structure. So even the nature of judicial review depended upon these classifications. All right, with me. All right, then they go into the 14th Amendment. Again, if you look at we'll get to the Harlan dissent in a few moments, but if you look at Justice Harlan, is accessing a train a privilege of citizenship? Yeah, I think it is. This is what Harlan wrote in civil rights cases. But again, civil rights cases said that no. Florida said no, that PRI only referred to these sub-treasury rights, so it doesn't access to trains. So again, you see how all these cases pave the way for Plessy. By the time we get to the 1890s, Plessy was not a surprise. This was an 8-1 decision. Right? This was not surprising to anyone at the time. It didn't even generate many headlines. People assumed, well, this is where we're going. Okay. And they say, was the 14th Amendment designed to eliminate all distinctions based on color? No. Referred only to these very narrow rights that the court recognized. Then they have an argument that we'll see over and over again. They say, can it really be that the 14th Amendment was meant to create equality? We have segregated schools in different states and the District of Columbia. And this is one of the more powerful arguments against equality. How could it be that the very Congress that passed 14th Amendment had segregated schools in the federal capital? There's a response. I'll get to I'll give the response as well. But if these laws are valid, you can separate children in schools based on their color. Why can't you separate passengers in a train? Again, as appalling as this issue might seem today, at the time, yet all these other segregations which were well established, why is a train car any different? All right. Sure, you have Strouder. They acknowledge Strouder, that when you have a right to a jury, this is a civil right that's protected. But passenger in a train is not such a right. All right. And then they get to the police power. Someone said this before. Is this regulation reasonable? Reasonable. Where have you seen this word before? Torts, like the reasonable person standard, right? Is there any clear definition of what reasonable is? Shh, no. Don't ask me what negligence is. I don't understand negligence to this day. And what does the court say? Who gets to decide if the law is reasonable? The legislature. How do you know the legislature thinks it's reasonable? Because they passed the law. The very act of passing this law is proof of its reasonableness. And unless there's some clear reason why the law is invalid, the court will not intervene. This is deference at its greatest. They're simply deferring to the legislature. You might say, Josh, who does this? McCulloch, right? If Congress thinks the Bank of the United States is valid, then that's enough for us. Now, you don't maybe care about a bank, maybe you care about segregation, but it's the same principle of deference. Any questions so far? Then it's we're gonna go downhill in a bit. Then they get to the last couple passages of the majority opinion. We'll do Harlan soon, I promise. Oh, yes, ma'am.
It's equal because it's all, is it equal because it's authored? It doesn't have to be like on the same caliber or same level. Like when you think about education, it's like, okay, yeah, they're both afforded the opportunity for education, but the resources are not the same.
So what's curious is the phrase separate but equal. In theory, at least, the train cars must be equal in station. I'll give you a very concrete example. You all know there's a law school in Houstonville, Texas Southern, right? Thurgood Marshall Law School. Do you know why it exists? You don't know why it exists? Yes, ma'am.
Somebody tried to apply the UT, Austin law.
Sweat P. Painter. Yeah, I think his name was Herman Sweat. Was it Herman Sweat, right? Yeah, SWEATT, Herman Sweat. He applied as a black guy, applied to UT Law School. He was not admitted. So the legislature said, well, we don't want to admit black people to the UT Law School. We'll make another one at Texas Southern, and we'll make it equal law school. And there was actually litigation because the funding, as you might imagine, between UT and TSU was not the same. So before you get to Brown, there was actually litigation saying, fine, you say separate equal, fine, make it equal, make the funding. And there were actually judges, in order to maintain Plessy, they actually required the funding to be equalized in various schools. There was a case from Oklahoma. Oh, I'm blanking the name. McCarran, it was an Oklahoma case where I think it was the University of Oklahoma Medical School, I can Google this one, where they actually required more funding for the medical school because the black medical school was not given equal funding to the Oklahoma University one. I think it was McCarran or McLaren, I can't remember the name. What was it called? McLaurin, I was close. MCLAURN, McLaurin, the Oklahoma State Regents, 1950. This was before Brown. And this actually had to do with segregation in Oklahoma medical schools. Okay. All right. Where was I? Okay. So the court, I want to get to this last part. This is the part that people usually get very on. So Homer argues that separation stamps the colored race with a badge of inferiority. And the court says that's not so. He says, and if you think it's so, it's only because Plessy chooses that construction. In other words, if Plessy sees this law as making him inferior, it's Plessy's fault. Whoa. And then the court says, if the colored race should become the dominant power in the state, and they should act along precisely the same terms, it would make the white person inferior. I just like, what planet are they living? I just kind of like, what planet are they living on? I mean, to look at the world in the 1890s and even entertain that possibility is sort of just sort of striking. Then the court sort of speaks the issue of integration. And here, just pause on this for a minute. He says, can prejudice be overcome by legislation? Can you actually have law to bring together the two races? And they're speaking from experience. There was an attempt at Reconstruction, to reconstruct, to rebuild the South. And you know what, guys? Did not work. Did not work. And what they're basically saying is, if the races are to come together, it's not going to be by us, judges. It's not going to be by the legislature. It's going to be by the people themselves. And if one race is inferior to another, the Constitution can't put them on the same plane. The legislature can't eradicate prejudice. And this part, they're probably right. That no matter what legislation you have, it doesn't change hearts and minds. And they say at the end, this is the question on which there's a difference of opinions and for the states to decide. So I think the variant, the basically saying like, yeah, we know this is probably bad, but we're not going to fix this for you. And it would take between Plessy and Brown almost 6 decades to even shift the debate and shift the momentum about how to think about these issues. But again, you don't get to Plessy without civil rights cases and slaughterhouse that came before it almost 30 years earlier. This is a 30-year swing between the 14th Amendment and Plessy. All right, I'll do Harlan in a minute. Any questions in the majority on Plessy? No? All right. So again, Harlan, again, I've said before, he's an icon of mine. And one thing I love about Harlan, I love a lot about him. One thing I love about him is he doesn't care to be alone. It's very hard to be alone at the center. Very hard. But look at the current court. John Roberts served in the lone dissenter, I think, once. There was one case, it was an 8-1. He doesn't like being by himself. Justice Thomas, bless his heart, is always by himself. Even on the conservative court, he's by those. You get a bunch of squishes, right? It's hard to be by yourself in law, especially on a court. And especially where you're going to be excoriated in the public and criticized. Criticism is not easy. And it's something that people don't like getting. So it's much easier to go along to get along. But Harlan was the sole dissenter in the civil rights cases in 1883, and then the sole dissenter in Plessy in 1896. But there's a value to being the sole dissenter. Imagine this was a 9-0 decision, right? Imagine this was 9-0. We would think that, of course, the majority was right. That was the only view of the day, right? No one else had a contrary view. It's only because Harlan wrote down this dissent that we even knew at the time people could think differently. People would read Harlan's decision in Black churches nationwide for decades, right? This was something that was like studied and like treated as gospel of how a court could think about the law. But again, it was just one dissent, just one vote. He speaks very clearly of a colorblind constitution. He says the Constitution does not permit any authority to know the race of those protected. Okay. He basically says that the court was wrong about the 13th Amendment. He says it did more than simply strike down the institution of involuntary servitude, that slavery was bigger, and that it cannot have these badges of slavery. He then turns to the 14th Amendment and he says, if this was enforced according to its true intent and meaning, it will protect all civil rights. What is he saying? He's saying Slaughterhouse was wrong. He can't quite say that, but that's what he's saying. Slaughterhouse was wrong. Crookshank was wrong. He then gives examples that are, I think, very sort of evocative. He says, okay, let's see where this ruling goes. If you can ban railroad cars, can you ban people from walking at one side of the street? Can you segregate a courtroom? You ever see To Kill a Mockingbird? Yeah. In fact, I visited a courtroom in Montgomery. It's like, oh wow, there's nice balconies, right? Why are the balconies there? It's not for theatrics, right? Because only people could go up there. So he's basically sort of seeing to the future where this is headed. Did you do in Property Shelley versus Kramer? Racial covenants, right? Where in fact you had laws that barred people of certain race from living in certain neighborhoods. So all the things that sort of Harlan foresaw came to pass. Okay. Then he gets this idea about reasonableness. Right? He basically agrees, like, look, it's very risky when judges decide whether laws are reasonable or not, right? That's a problem. But he seems not to be troubled by it because it's such a clearly blatant and racist law. Then he gets talking about the white race, and this is a part that owes people a little bit of difficulty. He says, in the eyes of the law, there is no superior race. He basically says, like, look, let's be clear. The white race is dominant, and that might be a matter of just observation. But in the eyes of the law, it cannot be. He says, our Constitution is colorblind and neither knows nor tolerates classes among citizens. All citizens are equal before the law. This was a big deal. Can you imagine sitting here in Jim Crow in the 1890s reading this? And you read the majority opinion, right? And you read this one back to back. And you say, wow, how could it be that this one guy sees it this way, and the other 8 of them, 7 of them sees it a different way? Right? There's a quote from Harlan to read. He says, if there's a black man who can get ahead of me, I'll help him along and rejoice. He meant that too. He truly saw a future where the white and black people could actually exist. And he knew it wasn't for his day. But when you write a dissent, and actually Justice Ginsburg's made this point before. Ginsburg once said that the reason why I write a dissent is not to speak to today, but to speak to a future generation that doesn't even exist yet. Right? You put this dissent down, and look, we're reading this case 200, 150 years later. We're still reading this opinion to speak to a future generation. So whenever you have an 8-1 dissent, think of, like, Justice Scalia and Morrison versus Olson, right? Or Justice Murphy and Korematsu, right? These lone dissents. They're not for the present day. Ginsburg would always say, Ginsburg once said about a decision, I don't understand how the majority sees things the way today, but maybe tomorrow they'll see it differently. And that's what you're speaking to. Okay. Harlan also says this will be like Dred Scott. That's a big deal. In other words, the reason why we have the 13th, 14th Amendment was to reverse Dred Scott. And yet, despite all those amendments, we're basically back at Dred Scott. That's a very serious charge to make. Okay. Any questions so far? But then we get to the part that everyone's like, wow, where'd that come from? But he says, hold on. There is a race that is so different from our own That we don't permit them to be citizens of the United States. I allude to the Chinese race. Was that? Was it? So Harlan had complicated views on Chinese people. Just put that mildly. Just I'll put subtly. He viewed Black people as Americans, just like him or others. He viewed the Chinese people as invaders. Basically come from foreign land and trying to take our jobs. Whereas the Black people were brought here involuntarily and were basically put to bondage. So he had a kinship with the freedmen that he did not have with Chinese people. And it's sort of this juxtaposition is like, whoa, where did that come from, right? But I think we have to study people as they are. And even perhaps the most enlightened member of the Supreme Court in the 1890s still had these views on Chinese Americans. Okay. All right. That's all I got on Harlan. Questions? Heavy lecture, right? This is real heavy. Yes, sir. You want like this?
Yeah, I guess.
Sure, go for it.
The part I find confusing is just like, with everything going on in the country at this point, I don't understand how there's really good, like, different progressive moves that are going on in the country.
So look, I'll describe it like this. Jim Crow didn't emerge overnight. It started in phases, right? So the earlier phases were cases like where private businesses would segregate. And the court said, okay, you can do that. And then the government said, okay, we'll mandate segregation so long as that there are equal accommodations. And the court said, okay, you can do that also. And then once you got to Plessy, it didn't matter anymore if the actual accommodations were equal. The court signaled that we're not going to be in the business of determining equality at all. That what the majority say, if this is to be done, it's by the people persuading you, not by court and legislation. So this was basically the last stop on the train where they said, we're out of this business. And once you got to Plessy, the southern states basically had a free hand to do whatever they wanted to their Black residents. It wasn't going to matter. There were laws, involving voting, a grandfather clause, a literacy test, a whole host of devices to prevent people from even having electoral power. Further questions on Plessy? So the sweep, again, we can go, I can, if my memory hit them all. We go, Prig, Fugitive Slave Act. Dred Scott declared Missouri Compromise unconstitutional. Civil War, bloody, gory Civil War. 13th Amendment, 14th Amendment ratified. The court declares Slaughterhouse that PRI doesn't mean anything. Bradwell the same, Crookshank. Don't get the Bill of Rights, don't get religion, don't get speech, don't get arms. And then you get to civil rights cases that Congress lacks the power to prohibit private segregation in these public accommodations. And you get to Plessy that the government themselves can impose segregation and doesn't stop. It's a story that's not particularly perhaps pleasant to hear, but you study on each of these cases one at a time, decide over the course of almost 50 something years. And that brings us to the 20th century. All right. Questions on that? All right, we're going to pivot our next class. We're not going to be talking about race for, well, maybe a little bit, but it's not mostly race classes for a few weeks. The next sort of topic is focused on economic liberties and the right of people to make contracts and whether the state can limit how many hours you can work and the wages you can pay. And one of the challenges people have is, wait a minute, the court's going to use substantive due process to try and protect economic rights, but Homer's sitting on the other train car. I'll just leave that one there. All right. Thank you all so much. I will see you all next class. Have a lovely day.